Good evening, everyone. I'm Professor Barlo Dermagradichin with the Armenian Studies program at Fresno State, and this is our spring lecture series of the Armenian Studies program. This evening's presentation is co-sponsored by the Society for Armenian Studies, which is co-sponsoring this presentation, a very special presentation, and I'd like to thank them for that co-sponsorship. Our speaker this evening is Mr. Karnig Kerkonian, who is a seasoned international lawyer and an experienced litigator, and he currently leads the international and federal practice groups at Kerkonian Dajani LLP, which focuses on complex litigation matters, Foreign Sovereign Immunities Act, and a variety of other matters. He holds a AB magna cum laude in government from Harvard University and 2 law degrees, a JD from the University of Chicago, where he served on the law review, as well as a postdoctoral diploma in public international law from Cambridge University. Mr. Kerkonian presents regularly on matters of public international law, the International Court of Justice, and the European Court of Human Rights. Before I go on to the presentation tonight, I just forgot that I did want to present to you very briefly some upcoming events for the Armenian Studies program. So I'm going to share the screen briefly with you. The Armenian Studies program has been holding a variety of events during each semester. And coming up next Friday night is going to be a special lecture on a new book that's been published by the Armenian series at Fresno State called Captive Knights. And the book will be discussed by Dr. Nanor Kabranian, who is the editor and really the driving force behind the publication of the book. And she's going to give a talk called Reading History, Remaking Memory with Zabel Yeseyan on translating an Armenian author's Turkish women. And this will take place on Friday, February the 25th through Zoom at 7 p.m. Pacific time. Then we're going to have our next presentation, which is going to be actually a co-sponsorship with the Philip Lorenz Keyboard Concert Series of the Gomidas Trio. And the Gomidas Trio is a new trio of Armenian artists who are going to be presenting a concert, Michael Kerkonian on piano, Arusak Baltayan on violin, and Gadik Terzian on cello. This will take place live, of course, Friday, March the 4th at 7:30 p.m. at the Fresno State Concert Hall. And the lecture is part of the Philip Lorenz Keyboard Concert Series at Fresno State. Tickets are required, and you can see the area there on the bottom, which gives you the ticketing information. Then on Tuesday, March the 8th, we're going to have our first in-person event in almost 2 years since the pandemic has begun. And the Armenian Studies program is presenting a talk called New Trends in Genocide Studies by Dr. Suren Manukyan. Dr. Manukyan was our Kazan visiting professor in Armenian Studies at Fresno State in the fall semester, but because it was in Zoom, we really didn't get to see him. But he is visiting the United States, and so we've asked him to come to Fresno and to give a live lecture in person at the University Business Center. It will be our first live event in almost 2 years on Tuesday, March the 8th at 7 p.m. And so we're looking forward to this talk because he's going to really give us an update on the new types of work being done in genocide studies. And then finally, coming up on Sunday, March the 20th, is the 34th annual Armenian Studies Banquet, which actually will be celebrating the 45th anniversary of the program. And we will be recognizing our graduating seniors, those receiving a minor in Armenian Studies, and also those receiving scholarships. This is our sort of signature event for the year. Again, it's been 2 years since we've held a live event, so we're looking forward to this. And if you're interested, you can check out our website, follow us on Facebook, and be able to see what's coming up with us in the next few years. So let me go back to the introduction. As I mentioned, Mr. Kerkonian has 2 law degrees, as we talked about, and he has been presenting regularly on matters of public international law, the International Court of Justice, and the European Court of Human Rights. He is also an adjunct professor of public international law at Artsakh State University. We invited him today to speak on the topic of Armenia v. Azerbaijan in the International Court of Justice. And what makes it so interesting is that he is, of course, a person that was present at that lawsuit, and he is actually a member of the Armenian delegation to the International Court of Justice case. So this gives him sort of a bird's eye view of what's taking place. So ladies and gentlemen, I'm very happy to present our speaker this evening, Karnig Kerkonian. Karnig?
Thank you, Barlow, and it's a pleasure to be with you here today. And I want to thank the Armenian Studies program at Fresno State University for making this opportunity available, not only to students, of course, at Fresno State, but to the community at large. I want to talk to you today about a case that is really important, a case that is shaping and defining a moment in international law, and importantly, shaping the role of international law as to the rights of the Armenian people. The case, of course, is Armenia versus Azerbaijan, currently pending in the International Court of Justice. And I think I'm going to try to share my screen so that we can explore this topic visually as well. So I'm going to give this a shot here. Let's see how this goes. Okay, I think that worked, huh?
Yes, we can see it. It's perfect. Yeah.
All right, perfect. And I want to introduce the case to you today, discuss some of its important contours, and I want to invite you to take an interest in it, to take stock in what is being argued and what is being decided in the case. And this is going to require us to take a step back, to gain some important perspective about how it is that we got here. Now, I know that many watching are not international lawyers, and moreover, that many are not lawyers. And that's okay, because I'm going to break things down in a way that is going to allow all of us to understand what this case is about and where we are. To that end, I'm going to discuss some context. What is the ICJ? Why does it matter? How did we get here? What are our claims before the World Court? And what exactly did the court decide on December 7th, 2021? What I'm not going to be talking about today is enforcement strategies, litigation strategy, and predictions. And I'm going to ask you to indulge me on that because it is a pending case. And given that this is a public forum, those types of strategic discussions are really not for public consideration. So what we will discuss, however, is significant and is a matter of public record, whether through the filings of the ICJ, filings with the ICJ, or the court's decision itself. And there is great value in understanding this case in this context. And that really is my goal today. Whether you are a concerned citizen or a lawyer, a student or an influencer, an academic, professional, or otherwise, there are important takeaways here for all of us. And we need to begin here at the ICJ to understand what the ICJ is and what it is not. The ICJ, which is also referred to as the World Court, is the judicial organ of the United Nations. It is the UN court where disputes between and among member states are decided. Now, not every case can be brought to the ICJ. It is in legal jargon a court of specific jurisdiction, meaning that it can only hear certain types of cases and make only certain types of decisions. And now this is important. It can't hear every case, every conflict. It can only hear some very special ones. And what are those cases that the ICJ can hear? In other words, what is the International Court of Justice's jurisdiction? And how do we get inside? The statute of the ICJ makes this really clear. Broadly speaking, there are two types of cases: contentious cases between states in which the court produces binding rulings between states that agree or have previously agreed to submit to the ruling of the court. And there are advisory opinions, which provide reasoned but non-binding rulings on some issues or questions of international law, usually submitted at the request of the United Nations General Assembly. Now, these advisory opinions don't have to concern a particular controversy between states, but they often do. And in this jurisdictional space, there is Article 36(1) of the ICJ statute, which opens an important door. It is referred to as the Comprehensory Clause, and it gives the court jurisdiction over, and I'm quoting here, matters specifically provided for in treaties and conventions in force. Now, what does that mean? Well, many treaties will contain a compromissory clause, providing for dispute resolution by the ICJ. Now, this is interesting. We've learned that we've learned some important measures already, that the jurisdiction of the ICJ is limited to certain types of cases, and that moreover, there has to be a reason for the ICJ to hear a case. And now we've also learned about this specific clause in the ICJ statute 36(1), which states that the International Court of Justice can hear matters as specifically provided for in treaties and conventions. Now, I want to bookmark that for a moment and jump over to one such treaty. a really special international convention. Let me see if I can move my screen here a little bit more. There we go. And what I'm referring to is a multilateral treaty, an international convention called the CERD. It stands for the Convention on the Elimination of All Forms of Racial Discrimination. Now, it's a mouthful, but we can break this down. The International Convention on the Elimination of All Forms of Racial Discrimination is a United Nations convention that commits its members to the elimination of racial discrimination and the promotion, of course, of understanding among races. It also requires its parties, among other things, to criminalize certain things, such as hate speech, for example. The convention was adopted and opened for signature by the UN General Assembly on December 21st, 1965, and it entered into force January 4th, 1969. Now, there was a reason brewing, of course, as to why the convention saw light in the 1960s. In December 1960, following incidents of anti-Semitism in several parts of the world, the UN General Assembly adopted a resolution condemning all manifestations and practices of racial, religious, and national hatred as violations of the UN Charter and the Universal Declaration of Human Rights. And it called on governments of all states to take, and I'm quoting, all necessary measures to prevent all manifestation of racial, religious, and national hatred. Now, debates in the UN General Assembly fell along a number of different lines. Some states did not want a binding convention and wanted instead some sort of declaration. But apartheid in South Africa played a significant role in shaping what was to become the CERD, as a number of African nations pushed hard for a more concrete step in international convention against racial discrimination. The drafting took a number of years, and when the draft was completed, it was not simply a declaration, but a convention, a multilateral treaty that states could consider and adopt and thereby bind themselves to as an international legal obligation. So what does the CERD actually give us? Well, first, the CERD defined for states' parties what racial discrimination actually is. Quote, any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on equal footing of human rights and fundamental freedoms. Now, this was a huge achievement in 1965 on the heels of more fascism in Europe, anti-Semitism again on the rise, and apartheid in South Africa. But that language found in Article 1 of the CERD is broad. It needed to be drilled down into specific prohibitions and limitations. So what were those drilled down prohibitions and limitations? And this is where the CERD gets really interesting for us. Article 2, which you see here in blue, condemns racial discrimination and obliges parties to undertake to pursue by all appropriate means and without delay a policy of eliminating racial discrimination in all its forms. Specifically, Article 2 requires that states' parties, among other things, not practice racial discrimination in public institutions, to not sponsor, defend, or support racial discrimination. Now, the next circle I have in blue is Article 5, because it expands on the general obligation of Article 2 and creates a specific obligation to guarantee the right of everyone to equality before the law, regardless of race, color, and here it is again, national or ethnic origin. It states that this means equal treatment by the courts and tribunals, and really importantly, it means the security of the person and freedom from violence. Article 6, also in blue, obliges parties to provide effective protection and remedies through the courts or other institutions for any act of racial discrimination. This includes the right to a legal remedy and damages for injuries suffered due to discrimination. Now, moving over to the orange circles, Article 3, it condemns apartheid and racial segregation and obliges parties to prevent, prohibit, and eradicate these practices. Article 4 of the Convention condemns propaganda and organizations that attempt to justify discrimination or are based on the idea of racial supremacism. It obliges parties with due regard to the principles embodied in the Universal Declaration of Human Rights, to adopt immediate and positive measures to eradicate these forms of incitement and discrimination. Specifically, it obliges parties to criminalize hate speech, hate crimes, and the financing of racist activities. Article 7, the last one I want to talk about today, obliges parties to adopt immediate and effective measures, particularly in education, to combat racial prejudice and encourage understanding and tolerance between different racial, ethnic, and national groups. Now, that's all fine and dandy, but this next point is really important. The obligation of a state under a convention, under the convention terms, requires that that state actually agree in some way to be bound by the convention. This is really one of the great cornerstones of international law, sovereignty. The state, by its own actions, must agree to bind itself to the convention. And this is important because not every state is a party to the CERD. Armenia is a party to the CERD, having acceded to it on June 23rd, 1993. And Azerbaijan is too. It acceded to the CERD on August 16th, 1996. And neither Armenia nor Azerbaijan has made any reservations to any provision of the convention. Now, what does that mean, reservations? Well, sovereign states can agree to a convention while at the same time not agree to be bound by certain articles contained therein. But Azerbaijan here agreed lock, stock, and barrel to all of the provisions. Accordingly, Armenia and Azerbaijan are both states parties to the CERD. What this means, of course, is that Azerbaijan has bound itself under legal obligation to conduct itself in accordance with the terms of the convention. In fact, like other states that have joined the convention, the CERD, it has made that promise to all of the other states parties that have also agreed to the convention. Now, in addition to the substantive articles we discussed a few moments ago, those are Articles 2 through 7, there are other types of agreements that states parties make when joining a convention. And that includes agreements with respect to mechanisms. Now, what do I mean by that? Well, one of the important things that states sometimes agree upon in joining an international convention is a mechanism for resolving disputes among them. How is one country going to raise and resolve a dispute with another state regarding whether the conduct of one violates the terms of the convention to which they're both a party? This is a critical question, right? What if one state violates the convention? Who decides and how? So, in addition to the substantive prohibitions and limitations outlined in the CERD, to which all parties have agreed to abide by, there are also procedural mechanisms in place to resolve differences between the parties. And here is where the CERD gets extremely interesting for our purposes. Article 22 of the CERD says that any dispute between two or more states parties with respect to the interpretation or application of this convention, which is not settled by negotiation or by the procedures expressly provided for in this convention, shall, at the request of any of the parties to the dispute, be referred to the International Court of Justice for decision, unless the disputants agree to another mode of settlement. So this is interesting. If the parties have a dispute regarding the application of the convention in relation to another state's conduct, then that state can request that the matter be referred to the ICJ, provided negotiations to try to settle the issue have failed. Put another way, and perhaps more specifically here, if Armenia believes that Azerbaijan has violated its obligations under the CERD, and Armenia and Azerbaijan have not been able to settle their differences by negotiation, then Armenia can request that the matter be referred to the ICJ for a decision. Well, I'm going to show you what happened here. On November 11, 2020, just hours after the signing of the trilateral statement, the Armenian Minister of Foreign Affairs sent a letter on this issue of Azerbaijan's violations of the provisions of the CERD to the Minister of Foreign Affairs of Azerbaijan. The Azerbaijan foreign minister responded to the Armenian foreign minister's letter on December 9th, 2020. What ensued thereafter was an exchange of more than 40 pieces of correspondence with Azerbaijan in an effort to settle the dispute between the parties as to Azerbaijan's violations of the CERD. In fact, Armenia and Azerbaijan participated in 7 full rounds of meetings in an effort to settle the dispute. The first was held in early March 2021, and the 7th round was held on September 14th and 15th, 2021. As Armenia explained in its application, and when I say application, I'm referring to the papers filed by the Republic of Armenia on September 16th. The cover page is what we see on our screen here with the ICJ. It's like the complaint or the petition, if you will. And Armenia explained that despite Armenia's attempts to resolve the dispute by negotiations, remember 40 pieces of correspondence and 7 rounds of talks, those negotiations failed. In fact, Armenia stated, and I'm going to quote from the application now, quote, Azerbaijan has steadfastly refused to acknowledge any merit to Armenia's claims and requested remedies. And the parties' basic positions today remain exactly the same as they were in the foreign ministers' letters of 11 November and 8 December 2020. There is no reasonable prospect that they will change. Accordingly, negotiations have failed such that the court has jurisdiction over the dispute. Here we are. Article 22 should be triggered. And thus the case places directly in the court's crosshairs Azerbaijan's conduct towards Armenians against its own obligations under the CERD. In other words, the court is asked to decide whether Azerbaijan's conduct violates its legal obligations under this convention. And here we see precisely what Armenia is claiming. It says, quote, in light of the foregoing, Azerbaijan, through its state organs, state agents, and other persons and entities exercising governmental authority, as well as through other agents acting on its instructions and under its direction and control, is responsible for serious violations of Articles 2, 3, 4, 5, 6, and 7 of the CERD. End quote. Remember those? We covered them with the circles. And here, we're moving from the how we got here portion of my presentation to that part which I mentioned at the top, where we'll be discussing what Armenia presented to the court. And let's get specific here. What was presented to the court in Armenia's application? Initially, the application presented to the court some very important historical context. It traced the history of the genocide perpetrated against Armenians in the early part of last century, a historical fact which Azerbaijan denies to this day, which saw mass killings and deportations and persecutions of the Armenian population in the Ottoman Empire and the South Caucasus. And it mentioned specifically how Enver Pasha's Army of Islam captured Baku from allied Russian, Armenian, and British forces in September 1918, resulting in another 20,000 deaths. It noted the Shushi massacres in March 1920, where the then Azerbaijan Democratic Republic troops carried out a systematic massacre of the Shushi Armenians. It detailed the depopulation and destruction committed by Azerbaijan SSR, the Soviet Socialist Republic, in Nakhichevan, reducing the Armenian population of 50,000 in 1917 to only 3,400 in 1979. And it alleged the destruction of Armenian cultural, religious, and historical monuments. The application introduced direct quotations from Haydar Aliyev, the previous president of Azerbaijan and the father of the current president, who admitted that while he served as first secretary of the Azerbaijan Soviet Socialist Republic, that he had tried to change the local demographics by, quote, increasing the number of Azeris there and reducing the number of Armenians. But the application went further still to put the CERD violations alleged in context. It described the events of February 1988, when Azerbaijani mobs indiscriminately killed, raped, maimed, and even burned alive ethnic Armenians in Sumgait. It described how in November 1988, Azerbaijan again engaged in massacres of Armenians, this time in the town of Kirovabad. The application noted that massacres continued when violence against Armenians erupted in Baku, referencing a note by the UN Committee on the Elimination of Discrimination against Women that stated that, quote, for 5 days in January of 1990, the Armenian community of Baku, the capital of Azerbaijan, were killed, tortured, robbed, and humiliated. The application also explained that throughout this period, Azerbaijan destroyed Armenian heritage, including dozens of settlements, cemeteries, memorials, khachkars, and inscriptions on a wide scale. The application presented to the judges on the court provided more context still. The April 2016 war, known as the 4-Day War, when in the early morning of April 2nd, 2016, despite the ceasefire, Azerbaijan launched large-scale military offensive against the Republic of Artsakh. It explained how during the 4-Day War that followed, Azerbaijan deliberately targeted the civilian population and infrastructure of the Republic of Artsakh, murdered and tortured servicemen and civilians, and mutilated the bodies of victims. The application discusses the attack by Azerbaijan on Tavush in July 2020, when Azerbaijan launched a military offensive against civilian and military targets in the Tavush province of Armenia. And that attack, the application notes, came less than a week after President Aliyev publicly threatened to use force against Artsakh and Armenia. And of course, the 44-day war launched by Azerbaijan with the assistance of Turkey on September 27, 2020, which President Aliyev himself called the War of Salvation. And this is just some of the context that Armenia placed before the ICJ in its application. Then, of course, were the claims regarding the conduct complained of that violates the CERD. The application notes that Azerbaijan's use and toleration of racist hate speech towards Armenians is notorious. It cites the European Commission on Racism and Intolerance, which has observed that, quote, Azerbaijan's leadership, education system, and media are very prolific in their denigration of Armenians, and that, quote, an entire generation of Azerbaijanis has grown up listening to this hateful rhetoric. The application references the Council of Europe's Advisory Committee on the Framework Convention for the Protection of National Minorities, which has noted, and I quote again, widespread discriminatory behavior against persons of Armenian origin in Azerbaijan, and observed that the term Armenian, in fact, appears to be used and understood as an insult. The application further noted during the 44-day war, how during the 44-day war, President Aliyev referred to Armenians as animals. He also claimed, the application notes, that the Azerbaijani military was driving Armenians out like, quote, dogs, an insult which became a rallying cry for Azerbaijanis, showing the degree of hostility and hate speech within Azeri society. The application even referenced the Committee on the Elimination of Racial Discrimination, which noted with concern the, quote, repeated and unpunished use of inflammatory language by Azerbaijani politicians speaking about the Nagorno-Karabakh conflict and its adverse impact on the public's view of ethnic Armenians. The application explained to the court that consistent with what they have been taught and grown up listening to, large numbers of ordinary Azerbaijani citizens regularly espouse hate speech against Armenians. It explains that the consequences of the state's policy were on clear display in the summer of 2020, when at a mass gathering in Baku, thousands of Azeris called for war with Armenia and chanted, quote, death to Armenians. At the same time, the application notes there was a significant increase in hate speech disseminated over social media platforms. The application provided more still as to the extent of the state policy on hate speech against Armenians. The court was also presented with facts as to Azerbaijan's campaigns of atrocities and ethnic cleansing. Here, the application featured, for example, quotes from Azerbaijani state officials. For example, a former deputy prime minister of Azerbaijan, who explicitly acknowledged while serving as mayor of Baku that Azerbaijan's goal is, quote, the complete elimination of Armenians. a former presidential candidate and modern Musavat party leader who called for the annihilation of all Armenians, stating that, quote, there should be no Armenian left in Azerbaijan. An Azerbaijani member of parliament who openly called on Turkey in an interview with the largest Turkish newspaper to exile Armenians from its territory so that it could be, quote, a country without Armenians. These are just some of the quotes that were featured in the application that was filed with the court. And of course, there was the stamp in the image on your screen. The application explained that in December of 2020, Azerbaijan began producing a commemorative stamp proudly depicting Nagorno-Karabakh being chemically disinfected. The stamp's reference to ethnic cleansing was so blatant and egregious that the Universal Postal Union declined to even register it. The application to the court also noted that during and in the wake of the 44-day war, numerous graphic videos widely circulated on the internet showed Azerbaijani forces murdering, torturing, and subjecting Armenian civilians and prisoners of war to cruel and inhumane treatment. Among other things, the videos depicted executions, including beheadings, and a variety of torture, humiliation, and mutilations. The application refers to a report by Human Rights Watch explaining that the victims can be seen, quote, on the ground, blindfolded and restrained, as their captors kicked, dragged, and stepped on them and prodded them with a sharp metal rod, end quote. The application explained that as a result of Azerbaijan's actions, tens of thousands of Armenians fled from the areas of the Republic of Artsakh that came under Azerbaijan's control. It also noted that Genocide Watch, a nonprofit organization and the coordinator of the Alliance Against Genocide, issued a genocide emergency alert, finding Azerbaijan to be at the penultimate stage of Genocide Watch's 10 stages of the genocidal process. Stage 9, extermination. The application to the ICJ also presented to the court information regarding how Azerbaijan condones and rewards atrocities committed against Armenians. It introduced the example of Lieutenant Ramil Safarov, an Azeri national who, while attending a NATO English language course in Hungary with an Armenian soldier, Lieutenant Gurgen Margaryan, broke into Margaryan's dormitory and attacked him with an axe as he slept, killing him with 16 blows to the head and neck. The application recounts how Safarov then tried to break down the door of another Armenian staying in the dormitory, Captain Haig Makuchian, yelling, quote, open the door, you Armenian. We will cut the throats of all of you. The application detailed that despite Safarov being convicted of murder by a Hungarian court, he was extradited to Azerbaijan, and upon his arrival in Baku, Azerbaijani authorities immediately pardoned Safarov. Armenia presented to the court that Safarov was also praised as a hero, a patriot, and a role model, that he was promoted to major and even given back pay for the 8 years that he spent in a prison in Hungary. The Armenian application to the ICJ noted the CERT committee's concerned reaction. Quote, by welcoming a citizen of the state party convicted of murdering an Armenian as a national hero, and by pardoning and releasing that person upon transfer, Azerbaijan condones racial hatred and hate crimes and denies redress to victims, end quote. Importantly, Armenia's application to the court even noted the European Court of Human Rights holding that there was, quote, an overwhelming body of evidence indicating that the various measures leading to Safarov's virtual impunity, coupled with the glorification of his extremely cruel hate crime, had a causal link to the Armenian ethnicity of his victims. But there was more put before the International Court of Justice in Armenia's application, such as daily discrimination against Armenians. The application explained how Azerbaijan had directed or otherwise facilitated the illegal displacement of Armenians from their own homes. In a telling example, the application explained how the prevailing attitude towards Armenians is so negative that a Baku-based newspaper, Gündelik, openly called upon the Azerbaijani government to create a separate department within the Ministry of National Security to, quote, investigate the population for the presence of Armenian blood, so that, for example, quote, parents who want to marry off their daughters or sons could contact that agency to find out whether there are blood ties to the Armenians among the future relatives. According to the newspaper, this would ultimately help, quote, clear Azeri blood from mixing with dirty Armenian blood. The application also recounted, of course, Azerbaijan's destruction of Armenian cultural heritage. It spoke of the Julfa cemetery in the exclave of Nakhichevan, which once boasted the world's largest collection of Armenian khachkars from the 15th and 16th centuries, but nothing any longer. It noted that the destruction has been acknowledged and denounced by the International Council on Monuments and Sites, the European Parliament, and international press reports, which have condemned Azerbaijan's acts as, quote, the worst cultural genocide of the 21st century. Recently released satellite images show that other centuries-old Armenian heritage in Nakhichevan has also been covertly destroyed over the years, says the application. It states that notwithstanding Azerbaijan's statements that there's no such thing as Armenian heritage in the Nakhichevan Autonomous Republic, simply because Armenians never lived there, and that, quote, non-existing sites or cemeteries cannot be destroyed. In addition to detailing the actual destruction, the application further demonstrated that Azerbaijan has not only destroyed Armenian cultural heritage, it has also sought to erase or reinvent it. It has done so through redefining Armenian monuments as, quote, ancient Azerbaijani landmarks or as, quote, Caucasian Albanian in origin. For example, the application introduced evidence that in his visit to the Hadrut region in March 2021, President Aliyev recast Armenian heritage sites as Albanian. He further labeled the Armenian inscriptions on the walls of an Armenian church as fake and indicative of Armenia's, quote, false history. Of course, the application also reminds the court that Azerbaijan has still not permitted UNESCO to conduct an independent mission to draw a preliminary inventory of significant cultural properties as a first step toward the effective safeguarding of the region's heritage. The application, of course, also recounted Azerbaijan's destruction of Armenian cultural sites, escalated during the 44-day war and continuing since. It highlights two precision strikes hours apart against the Holy Savior Gaziantep's cathedral in Shushi, destroying part of it and injuring civilians who were inside the cathedral at the time. It also notes that when asked about the attack on the cathedral, President Aliyev himself admitted that the church was not a military target. This and more was put to the court. But Armenia thought something else important, something really crucial on the procedural side of things. We know the case was filed, but we also know that the clock keeps ticking as Azerbaijan's violations continue to accrue and the risk of irreparable prejudice is poignant. Armenia asked the court to act by way of urgency pursuant to Article 41 of its statute. And Article 41 states, and I'm quoting, the court shall have the power to indicate, if it considers that circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party. Armenia thus sought immediate relief, while the case is still pending on the merits. Armenia stated, and I have the quote up on the screen, on the basis of the facts set forth above and in the application, Armenia respectfully requests the court, as a matter of extreme urgency, to indicate the following provisional measures pending its determination of the case on the merits. In other words, while the case on the merits is still pending, Armenia asked the court to indicate provisional measures to put in place now, while the case on the merits is going through the normal case process, which takes time. Armenia focused its efforts in this regard on a number of specific areas as a matter of extreme urgency, including, and I state this without limitation, the murder, torture, and abuse of Armenian prisoners, hate speech, and the destruction of cultural heritage. Armenia also requested a hearing to decide its request for these provisional measures. The court allowed for oral hearings, and those oral hearings were held in October 2021. On your screen is Yelishe Giragosin, the agent of the Republic of Armenia to the International Court of Justice and the head of our delegation to the ICJ. Among other things, Armenia argued that the risk of mistreatment to Armenians in Azerbaijani captivity is real and urgent, and is evidenced, for example, by authenticated videos showing Azerbaijani troops abusing Armenians who were subsequently murdered while in custody. The application apprised the court of video footage showing, for example, an Armenian serviceman, Eric Mkhitaryan, in a crawling position on the ground while an Azerbaijani soldier holds the back of his neck and shakes him. Surrounding him are other Azeri soldiers pointing their rifles at him, while one soldier orders Mkhitaryan to repeat, Gharapagh, Azerbaijan. In April 2021, the application notes that DNA evidence confirmed that Eric Mkhitaryan had been killed. Armenia explained that Armenian civilians have not been spared either. Arsen Gharakhanian was captured by Azerbaijani soldiers at his home in Hadrut in mid-October 2020. And the application notes that video footage released in early January 2021 shows Gharakhanian being forced to say Gharapagh is Azerbaijan. His body was subsequently found on January 18 with visible gunshot wounds. Armenia's application referenced other sources still. Human Rights Watch expressed a concern about the treatment of Armenian prisoners of war, finding that, quote, Azerbaijani forces subjected them to cruel and degrading treatment and torture, either when they were captured during their transfer or while in custody at various detention facilities. Human Rights Watch also found, notes the application, that, quote, Azerbaijani forces used violence to detain civilians and subjected them to torture and inhuman and degrading conditions of detention. The application and the request also speak of the European Parliament's expressed concern, grave concern, and I'm quoting, about credible reports according to which Armenian prisoners of war and other captive persons have been and are being held in degrading conditions, and that they've been subjected to inhuman treatment and torture when captured or during their detention. The application provided that instead of releasing them, Azerbaijan has aggravated their mistreatment by prosecuting captives on fabricated charges, with most already having been convicted to years of imprisonment in its prisons. Armenia argued that these individuals continue to face a grave risk of torture, abuse, or other mistreatment at the hands of the Azerbaijani authorities. In the upper left is Konstantinos Salonidis. He's head of the legal team at Foley Hogg, the firm representing Armenia in the proceedings. The remaining photos are of members of some of the members of our Armenian delegation and council at The Hague. In demonstrating the urgency on the cultural heritage front, Armenia referenced numerous videos and images to show Azerbaijani soldiers and mercenaries vandalizing or destroying Armenian churches, gravestones, and other cultural artifacts during and after Azerbaijan's aggression in the 44-day war. It introduced statements by the co-chairs of the Minsk group expressing their concern about, quote, the preservation and protection of religious and cultural heritage, while the UN Secretary General acknowledged, quote, the need to introduce effective international mechanisms to protect and preserve the Armenian historical, cultural, and religious heritage in the Nagorno-Karabakh conflict zone. The application maintained, notwithstanding Azerbaijan's disingenuous professions of willingness to allow UNESCO to visit, that the organization still has not been able to do so, despite widespread evidence that the destruction and erasure of Armenian cultural heritage is ongoing, and a real and genuine threat of further future destruction and erasure remains. Armenia presented numerous examples, including the fate of the 200-year-old St. John the Baptist Church in Shushi, more commonly known as Ganansham, which was destroyed after Azerbaijanis occupied the city, while another church in Mekhakavan just disappeared. Similarly, it presented satellite imagery confirming that an early 19th century cemetery in Medztaret had been completely bulldozed and destroyed. It noted that satellite images confirmed that Azerbaijani forces destroyed a monument to the Armenian genocide in Shushi. Azerbaijan has begun, the application notes, a controversial renovation of Shushi's Razanchetsot's cathedral without consulting Armenia. Part of the alleged, quote, restoration work has been the removal of the cathedral's domes, as many know. Again, the application recounted Azerbaijan's concerted effort to reinvent Armenian monuments as ancient Azerbaijani landmarks or as Caucasian Albania in origin. The court was also presented evidence of irreparable prejudice and urgency. In other words, Armenia demonstrated how the Serb rights at issue are clearly threatened with imminent and irreparable injury. Armenia explained that although the power of the court to indicate provisional measures will be exercised only if there is urgency, that condition is met, quote, when the acts susceptible of causing irreparable prejudice can occur at any moment before the court makes a final decision on the case. Armenia explained that Armenians still under Azerbaijan's control continue to be at grave risk of execution, torture, or other forms of mistreatment. Azerbaijan also continues to damage, alter, or destroy, or allow the damaging, altering, and destruction of Armenian churches, gravestones, and other cultural and religious sites and artifacts. And Armenia noted that President Aliyev has continued his hateful rhetoric, repeatedly making offensive and degrading statements about Armenians, which not only increase the risk of further atrocities, but also aggravate and extend the parties' dispute and place Armenians under Azerbaijan's control under serious and constant threat. Armenia explained to the court that a, quote, real and imminent risk that irreparable prejudice will be caused to the rights in dispute before the court gives its final decision. Now, a quick institutional point. Pictured in the slide is the president of the ICJ, Judge Donahue of the United States, who presided over the oral proceedings in October. It should be noted that in addition to the 13 members of the court hearing and deciding the case, each state party to the dispute is permitted to designate an ad hoc judge of its own choosing. In other words, both Armenia and Azerbaijan designated one ad hoc judge to the World Court, bringing the members of the court hearing and deciding the matter to 15. On December 7th, 2021, after oral hearings, the court issued its decision as to Armenia's request for provisional measures. Now, the number 15 will be important for you to consider as we quickly review the key elements of the December 7 order as to Armenia's request for provisional measures. As to POWs, hostages, and other detainees held by Azerbaijan, the International Court of Justice ordered in a vote of 14-1 that the Republic of Azerbaijan shall, in accordance with its obligations under the International Convention on the Elimination of All Forms of Racial Discrimination, that's CERD, that Azerbaijan shall, quote, protect from violence and bodily harm all persons captured in relation to the 2020 conflict who remain in detention and ensure their security and equality before the law. What is interesting here is that even the ad hoc judge selected by Azerbaijan ruled in favor of this provisional measure and against Azerbaijan. As to inciting and promoting racial hatred, the ICJ ordered unanimously that the Republic of Azerbaijan shall, in accordance with its obligations under the International Convention on the Elimination of all forms of racial discrimination, take all necessary measures to prevent the incitement and promotion of racial hatred and discrimination, including by its officials and public institutions, targeted at persons of Armenian national or ethnic origin. Here, every single judge, including Azerbaijan's designated ad hoc judge, voted in favor of this provisional measure against Azerbaijan. As to cultural heritage, the ICJ ordered 13-2 that the Republic of Azerbaijan shall, in accordance with its obligations under the International Convention on the Elimination of all forms of racial discrimination, take all necessary measures to prevent and punish acts of vandalism and desecration affecting Armenian cultural heritage, including, but not limited to, churches and other places of worship, monuments, landmarks, cemeteries, and artifacts. Importantly, the court also ordered both parties to refrain from any action which might aggravate or extend the dispute before the court, or make it more difficult for the court to resolve. Finally, the court made an important legal point as to the force of the December 7 order. In paragraph 96, the court reaffirmed that, quote, its orders on provisional measures under Article 41 of the statute have binding effect, and thus create international legal obligations for any party to whom the provisional measures are addressed. A reminder to Azerbaijan that the court's order is legally binding on it. What does this mean? What is the impact of the order granting Armenia provisional measures against Azerbaijan? What will this change and how? These are important questions, certainly. And to think about that, I want to leave you with a few closing thoughts. First, the order itself is 9 weeks old, and the case on the merits continues. Second, as any student of international relations can tell you, states, even rogue states, try to justify their conduct internationally as being consistent with international law. An order by the ICJ, one imposing legally binding international obligations on a state, is really hard to ignore. The actual text of the written order is an important tool by which to promote the truth and attack misinformation. Third, I want you to think about the value of seeking justice in the immediate term, not waiting. The value in seeking justice and creating a historical and legal record of the claims, facts, and arguments presented, and in the World Court, no less. That has value. Fourth, there has already been immediate impact. The court acknowledged the representation made by the agent of Azerbaijan during the oral proceedings that the mannequins depicting Armenian soldiers and those displays of helmets allegedly worn by Armenian soldiers during the 44-day war have been permanently removed from the park and will not be shown in the future. Fifth, and as we assess the impact of the order going forward, I invite you to think about the impact that an order of the International Court of Justice would have in many spheres, such as the diplomatic, the humanitarian, and the geopolitical spheres, or perhaps in spheres in which you are active. For example, what is the role of an ICJ order before other UN agencies such as UNESCO or the Human Rights Council, or the impact of such an order could have on academic institutions' relations with other countries or other students or other institutions, or before decision makers in political or financial spheres. The order on provisional measures against Azerbaijan by the International Court of Justice is a significant victory for Armenia and Armenians. And while it is not a panacea for everything that may ail us, and I assure you there are no magic bullets and no judicial action has ever healed every human wound, this case and this order is a real win. It's a big win, and it's an important one. And wins matter. For the team, With provisional measures in place, the next step is the case proceeding to the merit stage, which will entail written memorials and further argument, and will take time. And I really, really encourage all of you to follow the case intently, to share updates about the case, to read the court's order for yourselves, and to learn about the legal battles that are shaping our collective Armenian landscape. We are moving forward, and we have already moved the needle in this forum, in this very important global forum, in a powerful and meaningful way. Thank you for your attention and your indulgence, and I want to thank Barlow again and Fresno State University for this opportunity. And I wish you all purpose and patience, and I hope that I have a chance to be with you again to describe important topics in international law, human rights, and the Armenian experience. And I think, if I'm not mistaken, Barlow, that you said there might be some questions.
Yeah, so let's go ahead and stop the screen sharing, and we're going to ask that people that are interested to ask questions to use the chat area. So as I mentioned at the beginning of Mr. Kerkonian's presentation, that there may be some questions that he cannot yet answer, so we'll just take that into account. And I want to thank him for his very clear and important explanation of just what is going on in the International Court of Justice. And so we do have some questions. If you want to take a look at it, Karnig, you want to read it? If it's one you can answer, you can read it out loud. And then, can you see it in the chat?
Yeah, I do see it in the chat, and I explained it kind of at the outset that unfortunately you're going to have to indulge me on not answering questions on enforcement, and the reason is that we don't want to disclose kind of considerations on how these things are monitored or enforced. Although I can say in a general sense that there are existing structures and mechanisms by which ICJ orders are enforced. But I do want to also mention, as I did kind of in my closing few thoughts, to really take a step back and think about what you've heard from states, what you hear from states that are behaving. I mean, you can look at the current Ukraine crisis, if you will, and at every moment there are every state tries to conform its behavior, or at least state that its behavior conforms to international law. And when you have an order like this that is outstanding like that, it's very hard for states to ignore that. And if provided the public is well aware of the actual language of the orders, so that there's so that misinformation and misrepresentation can't take place. It's very hard for states to get around those types of legal obligations. So in another talk, I'd be happy to get into enforcement mechanisms, and that's probably later down the road.
I have a question for you, Karnig. You mentioned toward the end about the merit stage of the case, and I was wondering if you could distinguish for us between the difference between the preliminary decision and then what the case is looking to do in the merit stage. Just what's the difference between those two?
Yeah. So in the provisional measure stage, there's a prevailing standard where the question becomes a matter of urgency. In other words, should the court, like let's look at a domestic example, or any court where it's going to hear evidence and make decisions, should the court make a decision prior to its normal case proceedings progressing? And that was really the issue on the provisional measures hearings and the decision that was issued. Now, this order is not a final order in the case in total, right? It deals with the provisional measures application requests of Armenia. So there of course is evidence considered at every stage. The question is the opportunities to respond, the memorials and the briefing that will take place. And frankly speaking, the merit stage of the case will take not a matter of months, but a matter of years.
Okay, and then we were talking earlier, Karnig, about where people can follow the case, and maybe you can put in the chat an idea to everyone, a couple of places, or if you want to just say it and then, or email it to me and then we'll get it to people, but maybe you can just say it a couple of places.
Yeah, so I think there's a couple of places where I encourage people to go. One is on Facebook or other social media. The Republic of Armenia agent to the European Court of Human Rights, which is Yelishe Giragosyan as well. He's the agent both to the European Court of Human Rights as well as the International Court of Justice. And as I mentioned, he's head of our delegation, the Armenian delegation to the ICJ. His page on his office's page on Facebook or other social media sites provides, or on the internet generally, provides information and updates regarding the case. Now, the documents that I refer to, for example, the application as well as the order itself, as well as other orders in the case and other filings in the case, can be found on the International Court of Justice's website. And I think it's ICJ you know what, let me tell you exactly what it is. ICJ-CIJ.org, and I can add that right here in the chat so people can go and actually pull up some of the documents and they can actually see and, oops, I think I sent that as a direct message. Let me just do this.
Great, and I think there are a couple more questions that perhaps you can address. One is, was there something that you felt you learned when listening to the case made by those representing Azerbaijan at the case? Is there something you could comment on, something that?
Yeah, I think I can, without getting too much into specifics, I can. One thing that became really apparent, and it was actually raised in the oral hearings, was a policy of mirroring, where Azerbaijan takes what Armenia says and mirrors it and throws it back, sometimes without any evidence whatsoever. And we see this in the PR world quite a bit. But I was actually surprised to see that. Well, perhaps not surprised to see it, but disheartened to see it actually in the oral proceedings.
And then there's a question regarding as someone. Hegnar as asking Wattenpau about, would you be able to offer any comments on the recent ICJ decision in Uganda v. Congo, which included reparations? Is there something that you would want to comment on?
You know what, and I know that maybe that's something I should discuss with Hegnar offline. I know that her knowledge of the cultural heritage stuff is powerful, and quite frankly, I don't want to get into the issue of reparations, because obviously those are endgame remedies that are really not at this stage yet in the proceedings. So
another question was about UNESCO, and the question is simply, how will UNESCO convince Azerbaijan to examine historical sites within the captured territories?
You know, and that's a great question, and you know, and I kind of invited people to kind of think about that. And I'm happy to get a question like that, because I have to say, as I mentioned at the beginning, the International Court of Justice is the United Nations court, right? It's the world court, but it's structured under the framework of the United Nations. And so is UNESCO, right? And I think that there's some real value. And again, the order is only 9 weeks old at this stage. But I have to say that I believe that an order by the International Court of Justice is going to have an impact, and should have an impact, on UNESCO's view of cultural heritage, UNESCO's view of its own obligations under its charter. Because as the court noted in Article 96, its decisions on provisional measures are of a legally binding nature. And as such, they form the body of law that governs this topic, governs this issue, this dispute. So it cannot be that the order itself is something that UNESCO is not going to be able to ignore, and frankly shouldn't ignore, shouldn't have, you know, I mean, we can get into more details. I have other views on that as well, but in keeping it to the subject of our discussion, is a dictate in terms of order, in terms of what Azerbaijan can and can't do or should do, that UNESCO can't ignore.
Great. And there's another question, perhaps commenting on, could you comment on the relevant scholarship that was included on the filed complaint, in other words, as footnotes? So maybe give us an idea of how much work went into preparing that that case and that material?
Yeah, and I think that's a great question. In fact, I think that's a question I really should have brought out in the presentation. It's just that trying to pack everything in, I didn't have the opportunity to do that. But there's really two sides to that, Barlow. I think that, one is, let me just say that, the footnotes are massive in terms of the annotations and the evidence that's cited throughout the application. That includes the scholarly research. And I think that we have to realize and see the value of taking all that work that has gone in, and this is work that's gone in over decades, quite frankly. And I think it's a real testament to what Armenians and scholars generally have done on these topics that has provided the wealth of information. And I'm not talking about just recently, and I want to talk about some of the more recent scholarship that's taken place, but it's a scholarship throughout the decades that have gone into creating the narratives of the historical context and the information presented to the court is extremely valuable. And even during the war, and I think this is something that really shows kind of the what I would, the wealth, if you will, of intellectual power that the diaspora had brought. Of course, there were references to reports by the Armenian Human Rights Ombudsman, the Artsakh Human Rights Ombudsman, but there were also a number of citations to third-party sources, NGOs, and outside organizations that really did quite a bit of work on collecting information and processing that information and putting out reports. And I think I can't overestimate enough how valuable I think that's the right phrase, but it's getting late here in Chicago, so I apologize, overestimate, underestimate. But let me just say that type of work has been invaluable. It really has, and it really came together. And I hope that when I described kind of what was in the application, I think people can see just how much source material was taken into the actual final document. And I encourage people, and I don't have the link directly, but again, it's at the icjcij.org page. You can actually pull up the application, and I encourage people to do that. I think it's important for us to really understand the work that goes in, and perhaps even motivate, and for people to understand that the work that is being done by academics, by experts, by scholars is not just esoteric work, especially on these issues. There's some real tangible value, and not just in terms of the thinking space, but now we see that value in the legal space. We see it on the activism space. So I think it's really important to encourage that. And I think by reading the application itself and the court's order, it's thick reading, but I think that it shows and demonstrates just the wealth of scholarship and information that has gone into this product, that will go into this product moving forward as well, and the value that we as let's say a global Armenian community should aspire to support.
Let's conclude with just maybe you can tell us about, there's a question about what's the next step in the proceedings. I think you mentioned briefly about the merit case, but has anything been scheduled? What do you see as the timeline for that?
Yeah, there have been things scheduled. I looked at the online to see what was publicly available at this point, and I didn't see what was publicly available. So let me just say that the way a case like this, and the next stages of this case are going to be a period of memorials where certain briefs, if you will be prepared and submitted to the court on various types of issues. Right now, what's standing in the court obviously are, and you could find on the ICJ-CIJ site, those who couldn't follow the oral arguments on provisional measures at the time they were happening can go onto the site and actually hear the numerous hours of oral argumentation and presentment that took place at the ICJ. And it's, these are historical moments in the history, not only of the court, but extremely important historical moments in terms of the exercise of sovereignty of the Republic of Armenia. These are, there's many ways that sovereignty is exercised. Some of the most brute measures, of course, are military force and things of that nature. But, these are exercises of sovereignty, these types of cases. They're brought by the state on behalf of the state against another state in a forum that is built to hear them. And there's something really powerful and meaningful about that. And I encourage people to really get involved, to really try, like I said, not only following the relevant sites on social media, but really get into the documents. I think that, if people are listening to this talk, my guess is that they're interested in these types of, let's say, intellectual pursuits. And I think that one would find, whether they're a historian, an interested citizen, a lawyer, or what have you, or an expert in some capacity, that they would find the application to be a really telling piece of our story. And it's a story that's told, not to one another, but, arguably one of the most influential courts in the world.
Thank you, Karnig. We really appreciate your time and effort to prepare this very wonderful, very clear explanation of this important case. And for anyone, again, that would like to follow this again, please go to our YouTube page, the Armenian Studies Program YouTube page. Thank you again, Karnig, and thank you to our audience. And please join us next week, next Friday night, for our next presentation in the Armenian Studies